Hello everyone, my name is Viren Dayal. I'm a custom broker, trainer and a faculty. Today I'm going to talk to you about another important section of the Customs Act, and that is known as short levy.
For latest updates, subscribe to our channel and press the bell icon.
What is short levy? Before I begin, let me give you a little background note of in the current scenario of compliance-based clearances. Many importers get a letter from customs asking to pay duties which according to the customs is short levied, and many a times the letters also say that the notification benefit taken by the importer or the classification claimed by the importer is not legal and proper, and why shouldn't the customs authorities claim a short levy. So short levy is a recovery section. So recovery of duties not paid, short paid, not levied, short levied or erroneously refunded under the Customs Act. So the main provision which talks about short levy under the Customs Act is section 28. So section 28 is broken up into two parts. Under section 28 subsection 1 and under section 28 subsection 4. Under section 28 subsection 1, the law provides that where any duty has not been levied, not paid, short levied or short paid or erroneously refunded other than collusion, willful misstatement and suppression of facts. That means innocently it was not paid, there was no collusion or there was no willful misstatement or suppression of facts, there was no connivance or there was no guilty mind or something like that to evade duty. In such case, the customs will issue notice within 2 years from the relevant date. Relevant date here, let us presume, is the out of charge date of the import bill of entry. So when the goods come into India and upon filing the bill of entry, payment of duty, etc., you get a customs out of charge, and that is the relevant date here, the customs out of charge date. Within 2 years, a notice is to be served. However, in the Finance Act of 2018, the government enacted provisions that before you serve a notice, you must give a letter to the importer for pre-notice consultation to elicit his response regarding the duty liability which according to the customs has to be paid and whether or not it should be recovered from the importer. The fact that there is no collusion, there is no willful misstatement, and there is no suppression of facts, the limitation period to give a letter is before the expiry of 2 years from the relevant date. So again, let the relevant be date, the customs out of charge date. From that date, within 2 years, the customs can issue a notice. But before the issue of the notice, they are obliged to follow the procedure laid down under the pre-notice consultation regulations 2018, and a consultative letter should be given to the importer to seek his response before the notice is issued under section 28 subsection 1. The importer here can reply as per the time stipulated in the regulations and also can seek a personal hearing with the proper officer of customs. Once the consultative procedure is over, as per these regulations, if the importer has taken the option to meet the custom officer and the custom officer is satisfied on the representation made by the importer that no duty should be levied, in that case he will not issue a notice. But after consultation done or not done, in case the importer has not opted for it, the custom officer will issue a notice under the provision of section 28 subsection 1. These are the broad parameters. The notice will state the amount of duty to be paid along with interest under section 28AA of the Customs Act 1962. The importer may decide to pay the amount along with the interest or may seek adjudication procedure as mandated under section 28 subsection 8. We'll come to that a bit later. So these are the broad parameters of section 28 subsection 1. Let us now talk about the other type of a short levy, which is under section 28 subsection 4. Under section 28 subsection 4, a notice is straight away issued to the importer or the exporter. That means there is no pre-notice consultation which is there under section 28 subsection 1. Under section 28 subsection 4, it is presumed that there is collusion, there is willful misstatement, and there is a suppression of facts, and therefore no pre-notice consultation will be done, and straight away the importer or the exporter will get a notice saying that why this amount specified in the notice along with the interest should not be taken from you. Here the limitation period is 5 years. That means for all the cases pertaining to section 28 subsection 4, the limitation period to issue the notice is 5 years from the relevant date. Let us again presume the relevant date is the out of charge date of the goods cleared for home consumption under section 47. The notice will say that if the importer admits the liability and pays the same along with interest under section 28AA within 1 month, in such case the penalty will be levied on the duty demanded of 15%, provided the amount in the short levy notice, that is the duty amount, along with interest is paid within 1 month, and the penalty also is paid within that time, then the penalty amount will be 15%. Interestingly, here the notice, that is under section 28 subsection 4, can also be issued not only on the importer exporter but the employee, agent, general manager, anybody, because it presumes collusion, willful misstatement, suppression of facts, and if it's a private limited company especially, it attracts the provision of section 140 also. Now the importer or the exporter, the assessee may decide not to pay the amount as demanded by the proper officer under section 28 subsection 4 and may seek adjudication under subsection 8 of section 28, and accordingly the AC or the DC, which is the proper officer out here, will be obliged to give a personal hearing in both the cases. That means under 28 subsection 1 and also under section 28 subsection 4. On a hypothetical case, if there are two importers who meet the same AC under section 28 subsection 1 case for adjudication, and also on the same day the other importer comes and meets the AC and the DC for his case under section 28 subsection 4, and the hearing is done, the AC and DC has to take on record the submissions made, the arguments done, and must pass an order within 6 months from the date of issue of the notice where the short levy provisions are under section 28 subsection 1. That is, absence of collusion, absence of willful misstatement, and absence of suppression of facts. Whereas the proper officer, that is the AC and DC, will get 1 year's time to complete the case and pass an order within 1 year for all the matters pertaining to section 28 subsection 4 from the date of issue of the notice to the importer and exporter. The provision also says that on certain circumstances the proper officer may be given additional 6 months and additional 1 year to pass an order, and even then if the order is not passed, then it will be presumed that no short levy recovery is to be done or is now not necessary, and also no short recovery can be done under the provision of section 28 where the amount is less than rupees 100. After the order has been passed in both the cases, that is 28 subsection 1 and 28 subsection 4, the importer or exporter can decide whether he or she wishes to seek further appellate remedies, that is go to Commissioner Appeals and then SISTAT and so on. And at some point of time the duty becomes admissible after the appellate remedies, and if it has to be paid, in that case now the penalty instead of 15% under section 28 subsection 4 will now be 25%, provided the duty and the interest under section 28AA, both are mandatory, have to be paid within 1 month from that particular date of adjudication by the proper officer, or within 1 month from the time the appellate remedies decision is made. And in this case, the penalty will be 25% and not 15%. But interestingly, the penalty of 25%, which has now been increased to 15%, is only for cases where there is a collusion, there is a willful misstatement and suppression of facts. There is no penalty for cases covered under section 28 subsection 1. These are the broad parameters of the short levy provisions which are covered under section 28 of the Customs Act 1962. I hope you found this video useful.
For detailed learning of all logistics subjects, visit www.logiveda.com.